Hi everyone. Hope you're all doing well and you enjoyed session one, which was looking at critical drug trial regulations in India. Now for session two, we're taking the conversation forward, and we're going to be looking at it from the issues of patent law and the implications it has on healthcare, both in terms of patent law, that is Indian policy, as well as international policy. Now, we have joining us a number of distinguished panelists and guests. Before we head to the panel discussion itself, as is the format, we have a keynote discussion. Now, the keynote address will be delivered by Justice Prabha Sridevan. She was a judge of the Madras High Court from 2000 to 2010, and then the chairperson of the Intellectual Property Appellate Board from 2011 to 2013. She has, during her tenure both on the High Court and the IPAB, dealt with several important cases pertaining to intellectual property rights, including the celebrated Novartis case from the Madras High Court, as well as India's very first post-TRIPS compulsory licensing case filed on the IPAB. Given her significant contributions to the law and policy on intellectual property rights, especially its interactions with the pharmaceutical industry, we're quite excited to hear from her what her thoughts are on this topic. We'll begin with the keynote address, and after that, we'll introduce the panelists and go ahead with the panel discussion that we had in mind. Justice Prabha Sridevan, over to you.
Thank you, SAMVAD, for inviting me to speak here. There have been tragic losses and unbelievable tragedy. So may I, without the permission of SAMVAD, be silent for just 30 seconds. Thank you. That was for those who are alive and those who are not. I have looked at the list of persons who are going to speak, and I see that everyone is very actively engaged in intellectual property space in whatever capacity. And I am the only one who is retired, but I am here. I'm going to talk about the tension between patent and trade in today's times. And I must confess that I haven't changed from the time I heard the Novartis case along with Justice R. Balasubramanian. Because I don't think it was just serendipity that made us define efficacy as therapeutic efficacy. That made a big change. Because efficacy, if we had not defined it that way, it would have made a world of a difference. And then I just wanted to pretend to this gathering here, like I would at any human rights workshop. Just imagine what today would be if there were no TRIPS. Because TRIPS is trade. Would we have been better off? India, I'm only talking of India. Would we have been better off? Would we have been without the shackle of several restraints that hamper us today? But I cannot blame it only on TRIPS. What we have suffered and what we have seen is due to lapse on many accounts. It is could be lapse in infrastructure of public health, lapse in governance, lapse in anticipation of what is to come, many, but that the blame apportionment is not what I'm going to do. I sincerely think that the rights of the patentee today must be considered at a much lower rung than we have till now. I belong to an extreme end of the spectrum, and some people know that. But I do think, if you remember, the many heads of states wrote last year to WHO that the rich corporations should not hold the right to health at ransom. And the UNHRC also confirms the primacy of human rights as the right to health over trade, IPR, and other bilateral investment. HRC resolution 32/L.23. Then the subcommission on the promotion and protection of human rights adopted resolution 2000/7 on IPR and human rights, says that human rights, the actual and potential conflict exists between TRIPS and realization of economic, social, and cultural rights. So how do we work our Patents Act today? How do we resolve the dreadful darkness that looms over us? Our patents right is fairly adequately drafted, but it all depends on how you work it. And desperate situations require desperate remedy. When South Africa and India ask for waiver, there are many voices that say, no, this will not include that. You still have to overcome that hurdle. I think when such a situation as this comes, you just cut the Gordian knot temporarily. I mean, make it clear that this is not forever. Make it clear that this is only temporarily, because what affects one part of the world does affect everybody. So it's not as if I can say my countrymen are secure and therefore I can just say everyone can do what they please. In one important case decided by the Australia High Court, it was connected with Myriad. Commenting about that, a writer says, the judgment raises the question whether a patent regime should allow quality of life to be the commodity of monopoly. Now, very often, in fact, even recently, even in these times, I have heard about, but what about the risks that the companies take? That is a question that is constantly raised. I must tell you that when I was chairman of the IPAB, I have asked the lawyers, how much did your company spend on this? It was not possible for them to answer. And it is not possible for them to answer. It's not that they were refusing to answer or anything. It is not possible. And the fact remains that they did not spend all that money on the research. In most cases, the patent holder will be somebody else and the company is just an assignee of the rights and gets all the rights. Fair enough. But what is it that the company is buying? The company has bought just the product. If you look at it like that, that righteous rage that swallows some people, what about this, what about that, you won't get it, because they have just bought the product. They have not spent on the research. That is, the person who spent time on the research is someone else. And in many cases, as we heard from the earlier speakers, the money spent has also been substantially from public funding. So this should not they recoup is a question that we seriously have to give an answer to. We can find out alternate solutions to that. Maybe I think Professor Shamnath Bashir has suggested compensatory regime payment, something like that. We have, it's not just the medicines or the vaccines where we should look at innovation. I think we should look at innovation in every aspect today. Now, today I read a headline that the FCRA will come in the way of the several whatever is flowing from outside. If though the FCRA has to be relaxed for this situation, if we are not able to make elbow room in this time when our sisters and brothers are dying and just suffocating, we are never going to do it. We are never going to do it. This is the terrible time, and these shall never be the time when one talks of what will the corporations do. In Emperor of Maladies, he speaks of cost and price. There is a difference. Price is what we buy the medicine for. That's not the cost. But trade is all about that. And these are the, you saw how long it took for USA to come this far. Because there are pushes and pulls, and no government is able to resist the pressures of the corporation. If you remember, I'm not saying that India garners all the glory, but definitely India contributed a great deal to the amelioration of AIDS. At that time, the pharma lobby did not have this hold because there was no product patent. And we could be the pharmacy of the world. When we heard the Novartis case, and the letters addressed to our ministers, which were also placed before the Supreme Court in its Novartis case, told people how the South African countries were looking to India. But today, every day, I'm sure all of you are getting messages. Your country is so in such dire straits. What are you doing? Are you safe? Are you safe? We have come to this position. And now I think we have to, this is not about the time to talk about monopoly. Whatever the law is, whichever country it is, I think this is the time to think of humankind as one. Science is there. I'm not a science student. I strayed into this intellectual property field. I don't know why. Science can only be a handmaid of mankind, not the handmaid of market. It is there only to serve us. Market is also there to serve mankind. This is a subject I get very passionate and angry about, because I see, I mean, when long ago, when we never thought something like this would happen, I have read articles which visualized something like this. Visualized a country which sat on a patent when the whole world was aflame with a virus. It's not even about ethics. It's about senselessness. And is this the way, as Thomas Eliot said, the world ends? I don't think we should allow that. And I don't think any other argument works to me. I'm willing to listen to the counter arguments, but to me, I think the medicines, the vaccines, the devices, whatever you may say, must serve us. I also heard, I have been listening to most of the morning session, and I heard about how courts are sitting on the cases. delaying. I'm not absolving courts of that, but I am only saying if there is an institution which can cut across various areas, various organizations that work in silos, I think it can be only the court. And I pray that the court will do the duty today. It has to. No other institution in my mind can serve that cause. I mean, it is federal in nature. I'm talking of our Supreme Court. And therefore, whenever a need arises in one state, it can address it by its orders. And this is not just about trade today. As I said, we can think of innovative ways of compensation. And the argument that without incentive and IPR stranglehold, I won't innovate. I don't believe that. I don't think that is true. It may be true only to a limited extent. And I have the comforting knowledge that even Professor Drucker said that he never expected his drug to cost so much. And I mean Gleevec. So I don't think any scientist will do that. So as I said, I'm not a science student. And as I also said, amongst you all, I'm the one who's retired. And so this is the way I look at today's problem. And will a solution come from our discussion? I really hope so. I really hope somebody will listen. And it's not magic, I know. It's not Harry Potter. It can't be. But I'm hoping that this is not a keynote address in that strict sense, but as I said, it has been two emotionally ridden times. And you will all understand. I think all of us are waiting for the light at the end of the tunnel. We thought it would be February, but the tunnel seems to be longer. Let's hope it comes soon. And I'm sure all you panelists will give us much food for thought. With that, I thank SAMVAD for allowing me to say what I have always been saying. It's just repetition of the same theme. Yeah, in Tamil, we call it the Tenja plate. Because long ago, you youngsters won't know, there was this disc kind of thing where you put a needle and play the music. And sometimes the needle will get stuck in the groove and it will say the same thing. 78 RPM it was called. So I belong to that time and my thoughts have not changed. If anything, I've become more reinforced in my view that the patentee's rights shall subserve human rights. Thank you very much, SAMVAD.
Thank you, Justice Sridevan, for the introduction to this session, and in particular for taking out those 30 seconds to make us recognize the suffering that this nation is going through at this moment. I think if there's one thing that comes through from the keynote address, it's that while we're discussing intellectual property rights, the law, the policy, we must keep in mind and we must ground it in the human suffering that occurs from the lack of medicines and the inaccessibility of medicines that can accrue from these rights in the first place. And that is the hope from this panel as well. To understand first, why is it exactly that the current law and policy is a barrier to medicines? And then secondly, how do we go forward from there and how do we change things around? And with that, I'd like to introduce the three panelists that we have today for this session. First, we have Professor Dr. Padmashree Gehl-Sampath. She is currently a fellow and senior advisor of the Global Access and Action Program at the Berkman Klein Center at the Harvard University, an adjunct professor at Aalborg University, and a professor fellow at the United Nations University. She's had over 2 decades of experience on law and policy design in areas of global trade, intellectual property, innovation, and specifically even with the pharmaceutical sector. And she has, in this capacity, worked and advised with several United Nations organizations, such as the United Nations Conference of Trade and Development, the World Health Organization, and the World Intellectual Property Organization, among others. Secondly, we have with us Mr. Prashant Reddy, who is both an academic and an advocate who specializes in intellectual property rights. He writes regularly on issues pertaining to intellectual property rights, both those that concern India and issues that plague the international forum. In particular, Mr. Reddy has also co-authored a book, Create, Copy, Disrupt India's Intellectual Property Dilemmas, which unravels the development of India's IP law and policy in modern times, and also looks specifically at the development with respect to the pharmaceutical industries. And finally, we have with us Mr. Rohan K George, who heads the intellectual property and information technology practice at SAMVAD Partners. He's had extensive experience in this field, dealing with clients, especially with the pharmaceutical and in the pharmaceutical sector and medtech clients. And apart from, of course, his extensive experience with the law, he's also been part of several policy engagements, including with the United Nations Conference for Trade and Development, as well as several other governmental bodies. And so the panel here today comprises a mix of people who have experience with international policy, Indian law. And so it would be quite interesting to see how both of these interact, both to understand the problems of patent law and the solutions that we can find. With that, I'll take it over to the panel, and Mr. Rohan K. George, apart from being a panelist, will also be helping us moderate. So I'll go over to him.
Thank you, Prashant. I think one thing that Madam Sridevan said in the course of her keynote stood out for me, which is that this is a bit like reading an excerpt from an article, a hypothetical scenario. For those of you who are unfamiliar with the niceties of law college, there is this tradition called the moot court, which is a sort of simulation where you take an extreme case scenario and test out the law in that extreme case scenario. Well, now I think we are living through the moot court. We are living through an extreme case scenario where our patent laws and intellectual property laws are being put to test, especially the flexibilities that we as the world, or at least as members of different countries of the world, have agreed to apply to ourselves and to each other. And now is a time when we really have to put basically our money where our mouth is and determine how much we care about public health and how much it makes a difference with regard to the derivation of incentive for commercial profit, for creation as well. So in that context, let's have a look at the scenario around the international as well as the Indian regulatory regime on patent law and how we can use that scenario in order to provide better access to public health. I will be for the most part, just moderating this and not saying very much beyond asking my fellow panelists to substantiate the small pointers I give. And in that context, I'm going to start off by asking my fellow panelists to give us a little bit of insight on the existing international and Indian scenario around patent law in the public health context. In that context, Padmashree, I request you to tell us what you can about the TRIPS agreement, the Doha Declaration flexibilities, and a little bit more about where we are context-wise.
So thank you, Rohan. Can you hear me now?
Yes, you're audible.
Okay. Yeah. So first of all, thanks to SAMVAD for organizing this and inviting me. And so to answer Rohan's question, so I think in a certain sense, we've come a long way since we started out in 1995, right? So we've had the big fight around the HIV/AIDS drugs access in 1999. We've then sort of brought up the question of compulsory licensing very prominently in the TRIPS agreement. in 2003, we had the Doha Declaration on the TRIPS agreement and public health, which then raised more widely the question of what does it mean to say we can compulsory license for public health, and what are we going to do for those countries which don't have domestic manufacturing capacity? How are they going to be able to compulsory license? And then we've managed to also formally amend the TRIPS agreement in the way of 31 bis, right? And all of this, I think, are significant sort of milestones in sort of trying to gain policy space, in trying to enforce certain ambiguities in the wording of the TRIPS agreement, and in saying, how do we actually work the public interest clause, which is just so vaguely enshrined in the TRIPS agreement, to look at issues of public health and access to medicines. That said, I think that, you know, there's been a lot of pushback in practical terms on how countries can actually use this space, right? So what started out quite, I mean, and I think that if you trace the history of compulsory licensing, then what happened since 1999, right? So what started out quite prominently and promisingly in the context of all these legal battles for space hasn't really materialized in that sense in giving countries the real space to enforce compulsory licensing as a workable solution to solve the question of access to medicines. So what's really happened is, I'll break it up into two sets of things. So on the one hand, you see that a large number of countries that did want to enforce compulsory licensing were not able to do so because of political pressures, right? And they basically, you know, resorted to the threat of compulsory licensing, but then they were lulled into a silence either by bilateral pressure enforced by the US or other major countries. Then a second thing that has happened is also that the US, and I think that this is a problem with, you know, with the patent law and its evolution in general over the last 20 years internationally, is that the role of the patent law as the barrier to access to medicines has expanded in general. And it has been, and this has happened through a range of regulatory exclusivities that have been recognized in the US and then used in free trade agreements to create a regulatory harmonization between what the US thinks should be the level of protection in the pharmaceutical sector and what should happen globally. And I think that this has constantly encroached on the policy space available to countries to actually enforce access to medicines. So in a way, so if I had to summarize and say conclude, I'd say, yeah, we've won some key legal battles, but we've lost a lot of practical space to enforce it. We don't have that space, what we had in 1995. And to go back to the hypothetical question that Justice Sridevan asked in the beginning of her sort of keynote here, how would the world look if we didn't have TRIPS? I don't know that, because for the moment, I'm actually trying to imagine a world where we only had TRIPS, you know? We would be in an infinitely better version of the world if we just had what we had in 1995, plus certain victories in terms of space in TRIPS flexibilities. And then if we could freeze us at that point of time where we just had the victories and not all the negative things that go with it, we'd be in a much better space.
Interesting. Thank you, Padmashree. And I guess the introduction of new bilateral treaties, which have introduced TRIPS plus flexibilities, haven't helped the situation any either. Do you feel that there's anything worth noting in the public health context as far as, you know, the rollback on flexibilities which were available under the Doha Declaration and how bilateral treaties may have affected them?
Yeah, absolutely. Look, there's so you have the question of market exclusivity, right? Then you've got the question also of giving extra time that's being utilized by clinical trials to drugs to extend the patent protection, which is also a key issue. Then I think another key issue that we don't discuss when we talk about patent law and its impact on access to medicines is what's the role of competition policy, right? You know, because patent doesn't do the same thing in every therapeutic category. It also depends on how the market looks. What are the barriers to entry? So you have some therapeutic categories where patent protection is not entirely giving the owner of the patent that amount of market power as it does in certain other categories, right? And when you see what's going on in bilateral agreements, you also see, to a certain extent, restrictions on the use of competition law. You also then, what I think was very worrisome for me is also the restrictions on technology transfer, restrictions on how to use FDI to promote technology transfer, which is another way where conventionally developing countries have actually used foreign direct investment to promote technology transfer in the pharmaceutical sector, and all of these restrictions. And then, of course, don't forget the definition of counterfeiting. Counterfeiting not as falsified drugs, but as drugs that actually encroach on trademarks. So these are all provisions in free trade agreements which are very worrisome from the perspective of access to medicine.
Thank you for that, Padmashree. Prashant, the question for you, we had a discussion about what the world would look like with only TRIPS or without TRIPS. Do you have any thoughts about that and how it would play out?
Yeah, Rohan. So, I mean, I think to answer that question of a world with or without TRIPS, we need to put into context the decision to sign TRIPS in 1994. Now, patent law has been a politically sensitive subject in India since 1950. That was when the first expert committee was set up by Shyama Prasad Mukherjee when he was the Minister of Commerce to study the new shape of Indian patent law. And from between 1950 to 1970, we saw 2 expert committees, 2 parliamentary standing committees, get really deep into the subject before the Patents Act 1970 was enacted to do away with product patents for pharmaceuticals and a section of other technologies also. In 1991, when the economy collapsed, when the government finally decided to open up the Indian economy, both in terms of investment and trade, that was the time the Americans were also putting pressure on India to sign TRIPS. And the deal that the political establishment was basing its calculations on was that we now want to export more of our goods to the Western market, especially textiles, which was the carrot that the Americans and Europeans were using during the negotiations. And if we want to access their markets, we have to make certain concessions for their products also. And in a world where America and Europe are primarily exporting intellectual property products and services, it's obvious that you have to give them some kind of protection. So the calculation then was a trade-off. I mean, you read Pranab Mukherjee's statements at the closing talks of when the TRIPS agreement was finally being signed. He clearly stated, that this is a trade-off that we are making. We want to export more textiles and other products to the West, and hence we are agreeing to protect their intellectual property subject to certain safeguards in India. So in a world without TRIPS, we probably would not have been exporting so much, say, in terms of textiles. I mean, right now we're being beat by Bangladesh, but up until now, we were doing pretty well on textiles. And textiles is one of those areas where India has historically had a strong economic, a comparative cost advantage. And Indian textiles for the last 1,000 years have been of extremely high quality. If there was no TRIPS, I would say that we wouldn't be exporting so much, in which case we wouldn't be generating so much employment, especially for the working classes in this country. And there would have been economic side effects to that extent. So we are protecting patents in India. I don't look at patent law in India as a means to incentivize production, to incentivize research and development anywhere. I mean, Indian companies are far, far away from developing a new pharmaceutical product, notwithstanding the kind of nonsensical drugs that are being approved during this pandemic by the Drug Controller General. We are very, very far away from actually reaching that stage of maturity of having capital, the resources and a research ecosystem to generate new path-breaking products. The only reason we protect patents is because we want to have a stable trade regime with the West, which will provide employment and other kinds of opportunities for our people. And if you look at the kinds of tensions you've seen between the US and China over IP, you'll know that IP can be a highly destabilizing factor when it comes to international trade, which is why we still have to, protect. We need to build on the victories that we have scored, in the international context while negotiating TRIPS, and work within those parameters. Because if you want to trade with the West, this is the only way to go ahead. If you want to go back to the pre-90s economy, where we're a closed economy and not trading with the West, then yes, you can do away with TRIPS completely.
Thanks, Prashant. And in that context, I think it's also worth spending just a little bit of time for us to look into how we have tried to implement these TRIPS flexibilities in our Indian legislation as well. I think it's worth just setting that as context. Would you be able to help us with this?
Yes, in the sense of
our compulsory licensing flexibilities, government working, and parallel importation flexibilities.
Yes. So I mean, on compulsory licensing, as it's well known, apart from that first compulsory licensing case, which was NATCO versus Bayer over a cancer drug, which Justice Sridevan adjudicated at the first appellate level, we have not had too many compulsory licensing cases. And part of this, it's not like people haven't filed, companies have been filing applications, but they haven't been able to cross the prima facie stage of evaluation by the Controller General. That is, the Controller General has to be convinced as a prima facie case that is made out by the applications and then issues notice to the patentees. So it should have been a relatively low threshold, but we see that the Controller General of Patents is refusing to cross even that particular threshold. And one of the reasons that has been attributed to this utter reluctance to issue compulsory licenses is what Padmashree had mentioned earlier, that is political pressure from the United States. So this is all based on hearsay, but the news reportage indicates that the American government was leaning on the Indian government to not issue any further compulsory licenses. And the problem in India is the Controller General is not actually an independent authority. He is an IAS officer who is generally working under the direct instructions of the Department of Industrial Policy and Trade under the Ministry of Commerce. So it is very likely that there are external pressures being put on the Controller General's office, because of which we've not seen any compulsory licenses. I think the real test for the Controller General of Patents is going to be these recent compulsory applications filed by NATCO during the pandemic. I mean, because if you're not going to grant a compulsory license during one of the worst pandemics that we are facing, then it's going to raise questions, I think more questions about the Controller General of Patents. I mean, the only problem perhaps is the drug that NATCO is asking for a compulsory license is not even on the national treatment guidelines. That's a separate issue. But yes, I mean, I think our failure to put in place a transparent process to assess the merits of these compulsory licensing applications is an indicator of a systemic failure somewhere. And one of the arguments that was being made, that Shamnath was making at one point of time is that the Controller General's office has to be more independent, or you shift this compulsory licensing function to the courts, because judges, whatever you say, are definitely more independent than an IAS officer sitting in the patent office making these calls. And I'll just end with one last statement. I think one of the big problems in India is, we are so focused on the international story, on TRIPS, this, that, we pay very little attention to the systemic faults within our own patent administration system. I mean, this is a system that was set up in, I think the Britishers set it up in 1912 or 1914, I'm not sure when. It's not changed that much. I mean, it's evolved a little bit, but post-TRIPS, there haven't been any significant changes in how we have looked at the systemic issues of the patent office, the courts, etc. So, I mean, we need to be paying a lot more attention to what is going wrong within our own system.
Got it. Thank you for that. We have one question. And by the way, in case it hasn't been mentioned earlier, please feel free to raise questions through the course of the segment. We will address them whenever we are reaching a reasonable point to segue into another point. So we have one question on Section 8 Clause 1 and 8 Clause 2 of the Patents Act not being applied and pro forma petitions for condemnation being allowed without reasoned orders. And petitions under Rules 137 and 138 only say the patentee is abroad and it took time to compile information. The overall umbrella of this is, what are the panel's views on the abysmal non-implementation of the Patents Act by the IPO itself? So, open to either.
Should I take this? Okay,
please.
I'll take this. So just to give you some background, I think the question was raised by Guru Natraj, who is now one of the leading lawyers for the generic industry. He's the brain behind these compulsory licensing applications that have been filed recently for NATCO. So to give you a background on Section 8, Section 8 of the Patents Act is a very unique provision in the Indian context. Even the international context, which requires a disclosure of all actions before all foreign patent offices to be made to the Indian Patent Office at the time of patent prosecution. So, for example, if, say, a European Patent Office or American Patent Office gives an adverse examination report vis-a-vis your patent application, although it is issued by a foreign patent office, that has to be filed with the Indian Patent Office. And this provision has been in the law since the 1970s. It's so as to equip the patent office, the Indian Patent Office, with a complete set of data and information, because there's always patent prosecution can be a very arduous process, and so every effort has been made under the law to ensure that the patent controller has complete information regarding the different aspects of the claimed invention. So this is a provision that hasn't been applied consistently in India, and I mean there's a lot of pressure from patentees to not enforce this provision. Their common argument that patentees make is that it's all available now on the USPTO website, on the EPO website. Why don't you just access it from there? I mean, if it's so easy, you should be providing that information proactively to the patent office. Where's the problem with that? But it's not done, and there have been some decisions in the judicial context. I think even Justice Sridevan had given a judgment, if I'm not mistaken. Perhaps she can add a little bit more on that, where the debate in the law is how strict should the courts be when it comes to non-disclosure of Section 8. Do we presume some kind of intention on part of the patentee of trying to suppress information? Or is it the case that, only if they don't disclose particularly damaging information that we hold it against them? In the US, if you look at American patent law and American patent litigation, the suppression of any kind of information which may pertain, to the patentability of an invention is taken very, very seriously. I mean, most of the patent revocations in the US happen because of the so-called inequitable conduct. That is, there has been suppression of some kind of information. And in India, the only way to ensure better quality of patent grants is to ensure the patent controller is equipped with the best possible information, which is why clauses like Section 8 need to be enforced very strictly. I think it would be great if you could hear from Justice Sridevan a little bit more on her experience with Section 8 as a patent judge.
I think I have consistently held non-compliance with Section 8 dissent titles, and I was roundly criticized for it because we were told that is nothing to do with the patent as such. So why do you deny them that? And if I may go away from this question to say something else about this, imagine there was no TRIPS, okay? I have often told my audience, please don't think patents is only about pharma, okay? Having said that, I committed the same blunder. When I said, imagine a world without TRIPS, I was only thinking of pharma patents. And that is my lapse, mea culpa.
If I may add something here, Rohan, I think that we should sort of so this question about why are we not holding companies responsible for not submitting information that they are by the Patent Act obliged to submit. It goes back to a wider systemic question of what is the philosophy of the Indian patent law now in the post-2005 context, and why are we not able to enforce the patent law and interpret it in that light? And I think, and I just want to say, I think we've missed the boat. If you see what's been going on in India since 2005, we've missed the boat in the sense that we've not been able to come up with, and here I have to once again say, Justice Sridevan's judgment has been a real light, and then we've had some small and big wins, but we've not been able to set a new standard for how do you actually enforce and balance innovation with access in the pharma sector from the perspective of the developing world. And I'm saying this because when you're in international debates again and again and again, previously we used to talk about Section 3D and how important Section 3D is and how important the interpretation of Section 3D has been to sort of ensure the generic industry in India to perform. Fine. Granted, let's put that aside. Now, what does it really mean that you want to enforce Section 3D, prevent evergreening, and you want to have a pharmaceutical sector that works in a proper manner competitively to deliver drugs that are needed in a situation where you have rampant demand for it, for access to medicines, not just in India, but elsewhere in the developing world? And how do you, implement the Indian patent law to make that happen? And what is the obligation of the Controller General, like Prashant said, okay? What is the obligation to show that, these are the compulsory license applications and these are the reasons why we've denied them? Where is the, why don't we have that kind of information? Why don't we say, okay, if this is the low barrier and we are not going to give compulsory license, this is the reason why we are not giving compulsory licenses anymore. And the truth of the matter is we don't know whether it's the US that has exerted pressure or the Indian government has decided to take a more friendly position towards the US government on its own. I don't know that. And I don't think we have enough information on this to make a call. The truth of the matter is that between 2011 and 2016, if you see the data, 100 compulsory licenses were issued internationally. And India has not issued them. There have been 100 compulsory licenses issued. And out of these 100 compulsory licenses which were deemed to be issued, 81 of them went ahead. In 19 cases, pharmaceutical firms or international pharma companies came up with donations or tiered pricing and they got the compulsory licenses canceled. So that you can say political pressure, lobbying, rent seeking, whatever you want to call it. But we don't seem to have a steady policy on how we are going to enforce TRIPS flexibilities, not only to promote our pharmaceutical sector, but also in the interest of access to medicines.
Thank you for that, Padmashree. And
may I say something here? See,
sure,
Padmashree, you said that you're not sure whether it is the pressure or anything. But every time the US issues that, what is it called? Some 302 or something. It's called something, yeah, right?
Yes, yes.
There is such a furor here, almost as if the headmistress has issued a report card. I don't know why we should concern ourselves with something that happens in some other country. We are a sovereign state, right? But that feeling does not percolate here. And Prashant is right. I am saying, why should I say I'm not saying? IP is more equal in some ways. And therefore, an IP office shall not be the ordinary bureaucratic office. But we have never progressed from that. So we just had one Controller General, Kurian. So it can't be an incumbent-based, it was such a wonderful judgment that he wrote. That was the basis for what the IPAB did. His was the basis. So it was so good, but we haven't heard of anything. In fact, I'm not even sure, Prashant, 3D has been applied. I do not know. I don't think so.
Yeah,
so there is no point in saying we have the law. It's there in the books.
True. And I think, it also ties back to one of the questions that that Guru had raised the first instance, that is on, how condonation of delay, etc., happens without reasons being provided. So one of the big problems that we've noticed with the patent office, and I'm going to get some flack for this, but also a lot of patent practitioners, is a very weak grasp of administrative law. And, like basic administrative law, like we're talking principles of natural justice, reasoned orders. And I don't blame the patent controllers or even the patent agents for this, because they're just not trained in it. So patent controllers need to be given a certain amount of rigorous training in administrative law. I remember this was it's there in one of Shabnad's papers also on adjudicatory independence of the patent office. Because if you look at, I think this is also reflective of a problem across government in India, where quasi-judicial functions are discharged by bureaucrats who don't have formal training in administrative law. And it's one of the big differences with the US. In the US, you have the system of administrative law judges, where basically these guys are trained lawyers. It's basically a judicial system within the federal government, against which a judicial review lies with an Article 3 court. That is your conventional court in the sense that we understand it. So this is an issue that we haven't given enough attention to, on the functioning of the patent office and its, the kind of training imparted to its officers. There will always be that one or two exceptional officers who will still produce, high quality decisions, irrespective of, despite not getting formal training. But we need to give a lot more attention to this. We also need to understand, like, for example, compulsory licensing. There was this op-ed that Shamnad and me had written 10 years ago in Economic Times on if compulsory licensing is a judicial function, because you're adjudicating a dispute between two private parties and you're deciding compensation. It's something like, say, a land acquisition dispute, right? Land acquisition disputes will go to a district judge when it comes to fixing royalty, because it is a judicial function. In the same context, why is the patent office, which is clearly an executive body, deciding these kind of issues? So there are important constitutional law questions also in this context. Is there a case to argue that it's unconstitutional for the patent office to be hearing such disputes on compulsory licensing, because it's a violation of separation of powers, which is a part of the basic structure doctrine of the country? And can we shift it to the judicial system, which is more insulated from political pressures?
Yeah, and on that question of training, just granting a compulsory licensing and deeming that a patent is against the interest of public health is not just a legal function. You need to look at the market. You need to see what's happening, right? And you need to really, there is a thin line between monopoly power and market power and how that gets exercised. And normally, if you see what's happening in Europe, for instance, right, you really need to understand the economics of competition, and you need to say, here's a place where it's not working. I'm going to invoke certain powers that I have, and I'm going to license this, okay? And that sort of training of, combining legal principles which come from a wide array of sort of like laws, not just patent law in the narrow sense, and looking at markets and seeing what's happening in different therapeutic categories. Where is the demand? How is the market structured? What is happening to the price of these drugs? What impact does it have for R&D and subsequent product introduction in these categories? And how am I going to deal with it? That needs to evolve. And there I still go back to the point I made, is that we don't have a very close link and the systemic link between the patent system and innovation in India. It's totally broken. It's not there. And we need to fix it. We had this in the 70s. We had a policy, we had a real strategy of how we're going to use the patent system to promote domestic capacity. And we don't have that anymore. And Prashant made this comment, saying that, we're not going to have new drug discovery in India for a long time. I don't see the companies getting there. I also don't see the companies getting there. But I think the reason for that is that we don't have really that systemic focus on enhancing the capacity of our domestic institutions, not just companies, but domestic public research, domestic agencies to perform the kind of activities that we need really to build that kind of capacity anymore. And we're not using the patent system to balance that out. We just have a patent act, which we might or might not use.
Thanks, Padmashree. In that context, I'd like to move us to a different track of discussion. Could someone spread some light on the question of how have countries in the past used the flexibilities we have in place under the TRIPS agreement and elsewhere, either in the compulsory licensing context or even in the context of public health exceptions? Do we have any precedent? Do we have any background? Do we have a case, basically?
So internationally speaking, right? So there's been actually a lot of countries have faced difficulties in using TRIPS flexibilities. So if I compare what's happened in India to what's happened in a large number of African countries, Latin American countries, and other parts of Asia, then lots of countries have had difficulties in using it. One part of it has been that many countries that wanted drugs and were fighting for access to medicines, but they didn't have domestic manufacturing capacity. So I think I did this study already in 2008 to 2009 on the 31 base arrangement, to find that empirically, okay, the barriers to use the 31 base arrangement are very high, and it's very difficult for countries then to contract a company from another place and to use 31 base. Now, then what's happened is parallel imports, for instance, is another thing that a large number of countries have used, right? So they've been using parallel imports, but they've come under a lot of fire for using parallel imports because Big Pharma, and to a large extent, has sort of complained about the fact that the products percolate back to rich markets and that it's a huge disincentive for them to engage in tiered pricing initiatives, right? Which they continue to do for GFATM or other sort of like international agencies, which are now trying to deal with specific disease categories like HIV/AIDS, malaria, tuberculosis, and so on. And so parallel imports, but it's still in use. And in most debates, it's widely acknowledged as something that should not be taken out because it reduces the incentives for pharmaceutical firms to unnecessarily engage in tiered pricing of a kind which is not good. Because mostly what you find is that although firms want to have differentiated prices in different markets, they're not basically based on the ability to pay. So very famous cases, hepatitis C, sofosbuvir, right? So the high income market price was at 84,000 US dollars per regimen, but in all middle income countries, it was offered at $42,000 per regimen, right? So countries like Chile, Malaysia, India had sofosbuvir at $42,000 per regimen. So then Malaysia sought to issue a compulsory license for the production of sofosbuvir locally in 2017. It succeeded. When Chile wanted to do the same thing, it was met with a lot of political backlash, and Chile didn't go through with it. Chile was then offered a sort of a lower price, and Chile was again lulled into silence. So these things, they have been difficult. They have enforcing TRIPS flexibilities has been difficult. Free trade agreements also to a certain extent come in the way of it, but I think that also what is becoming clear now is for a large number of countries and the work, when we do this kind of advocacy internationally, we try to sort of look at, is there a need to reopen the issue of TRIPS flexibilities and to look beyond what we categorize as conventional TRIPS flexibilities, like working requirement, right? It's not really forbidden by the TRIPS agreement. But most countries have not used it because there's a lot of legal commentary that says that, working requirement might go against Article 27, but there is no settled jurisprudence on that. And countries can use working requirement. So they can say, we're not going to give you market authorization if you don't work the patent domestically, especially when you have big markets, right? So in a recent paper that I just co-authored with two other colleagues at Harvard, we are arguing that we need to start looking at clearing legal space in the TRIPS agreement in a new way. We need to sort of expand that idea of legal space, especially in a post-pandemic world, and start educating countries. And an issue has also been the same thing what we observe in India, we observe it in a lot of other low-income countries, that patent attorneys, patent officers, they really don't have the requisite training to implement TRIPS flexibilities, to interpret TRIPS in the favor of national circumstances. So that's another thing that one needs to work on. But this kind of debate has now started, and I think it's actually a good time to have this debate.
Okay, thank you, Padmashree. Prashant, any thoughts on this aspect, or should we move on?
Can you just repeat the question once? It was on using TRIPS flexibilities enough?
Not just us, but have other countries had some amount of success in the past? I think especially in a public health scenario, in being able to use these flexibilities, and what kind of precedent do we have to work on in that context?
So I think Padmashree has covered most of it, but I just want to add a couple of points. There have been cases where we have made it tougher on ourselves to, we've gone beyond TRIPS, what TRIPS required, and we have shot ourselves in the foot. I'll give you one example. One of these is these IPR import rules. So this is not, so this is basically on when you're importing goods into the country. At the border, there has to be some kind of customs enforcement. IP owners love this because, basically the state is doing the work for them. And it's an easy choke point at which you can capture infringing goods. I'm not talking about necessarily counterfeit goods, even infringing goods. So in the Indian context, this is not specifically a public health issue, but under the IPR import rules that India notified in 2007 or 8, they covered even even patents. Although TRIPS required them to limit it only to trademarks and copyrights, we included even patents, and that caused a lot of problem for a lot of other sectors until, I think certain importers managed to lobby the government and get that particular, those rules amended and take out a little bit from it. But there are a lot of cases like this where I don't think we've done a proper evaluation. We're a bit too self-congratulatory on our attempts to, exploit the TRIPS flexibilities without actually doing a proper in-depth critique. Like, for example, I'll give you one last example. In the US, the way the government use exception applies is very different from how it happens in India. Basically, in the US, the government issues out a tender for anything, any product, even if it's patented. The courts are directly forbidden from issuing an injunction. At most, you can go to a court of claims to fix the royalties that are payable. In India now, we don't have, the provision doesn't work the same way. It's extremely complicated on the ground on, and how it works. But if you look at the Specific Relief Act, which was amended in 2018, in pursuance of ease of business, for public infrastructure projects, the law was specifically amended to prevent the grant of any injunction in case there was a public infrastructure project, in which case basically the courts can't do anything. So if your land is being taken away, you can still litigate on the compensation payable, but the court cannot stop the project from proceeding. Now imagine if we just had a simple provision like that in the Patents Act, wherein the moment the government issues a tender for anything, public health or public infrastructure projects, there's no question of the court issuing an injunction to restrain the infringement of the patent. At most, you go to the court and you can ask for royalties, which the court will grant. So there's a lot of issues on procedure, etc., where, which not directly related to compulsory licensing or the specific public health exceptions that have been carved out in TRIPS, which could make life a lot easier for the government in a public health context. I just don't think we've done a good enough job on that front.
Thanks, Prashant. And on that front, I think I recall that this issue of customs linkage is one of those where the courts actually did manage to intervene in order to inject some sanity into the situation. I think where Justice Bhatt's order found that I think the customs department is not entitled to make determinations of what is infringing and what is not, and it's actually a determination.
I think that was the drug regulator. They were trying to link up the drug regulator and
the drug regulations as well. Yeah.
So there was a Bayer case
where they had comments on that front in the context of customs as well.
Yeah. So I mean, that case was not about customs. It was about drug regulation, where basically Bayer had petitioned the court to force the Drug Controller General to make an assessment of whether or not a patent was being infringed at the time of granting regulatory approval. Now, this is not a TRIPS measure. This is a TRIPS plus measure, which the Americans have negotiated into certain international, bilateral treaties. And Bayer was, trying to do the same thing in India through the judicial route. Basically, they're trying to argue that the state cannot willingly aid in the infringement of a patent. And they were reaching for the stars with this case because it was a difficult remedy to ask for to begin with. And Justice Bhatt was, he heard this case as a single judge, the Delhi High Court, where he shot down the request and pointed out very expressly that this is not that the law clearly does not require the DCGI to do any such thing. And there were very practical reasons that a lot of public health activists and a lot of academics oppose any kind of linkage, because if you understand how the DCGI functions, they can barely do their basic function of approving new drugs in a transparent, scientific manner. Asking them now to sit and read a patent document, interpret the claims, and decide whether a drug is infringing or not is just impossible. So that was luckily one thing that was shot down. It was, I think it went up to a division bench, and then the Supreme Court refused to even entertain an appeal.
Noted. So in that context, I think, especially as in the context of the last year or so, we've seen efforts by a number of countries around the world to try and make use of patenting flexibilities, use compulsory licensing provisions, other health provisions to address the pandemic. I mean, there have been initiatives led by Chile, Israel, Canada, Brazil, and you even have private initiatives. Would you like to discuss what's happening right now in that scenario, both as far as countries are concerned and national organizations and private organizations? Padmashree would like to start.
Yeah, sure. Great. So let's go back to what happened first. So, you know, Costa Rica submitted this this proposal, right, at the WHO. It was the initiator of this technology access pool. And at the same time, you also had actually, I think around the same time, about a month or so later, you had the COVAX facility, which came out of the ACT Accelerator, you know, which is jointly now led by WHO, CEPI, and Gavi to promote access to medicines. Now, so what this does is that this somehow bifurcates once again internationally the discussion on access to knowledge and access to technology on the one hand, and then access to medicines on the other, right? So it's a sort of it does in a certain sense what I would say is the hallmark now of global health diplomacy in a certain way, is that we're not going to discuss access to technology around, you know, in the same way that we discuss access to medicines, right? So now I want to focus on what's been happening on access to technologies, because I think that's really important. Because on the access to technologies front, since then, there's been a lot of momentum at WHO, especially saying that a lot of people have rallied behind COVAX and the delivery of medicines, vaccines particularly, but there hasn't been the same amount of traction on the CTAP mechanism, right, that the WHO has founded. And so a large number of countries have sort of like, you know, laid an emphasis on that. Now, at the same time, you know, countries like India and South Africa have proposed this TRIPS waiver. And this TRIPS waiver now has been ongoing for quite a while. A lot of countries have signed on to it. And most recently now we've heard that the US has come out in the support of the TRIPS waiver, right? Now, what's going to happen there, and whether we're going to see, you know, a true TRIPS waiver in the context of this pandemic, which covers all technologies, and what's going to happen, I honestly don't know. And we have to wait and see what happens in the WTO. But let me talk to what does it mean when we say we want a TRIPS waiver, right? So I want to just raise a couple of questions on what is access to patents in this context really the same as access to medicines? When we have access to patents, are we going to be able to produce, and what does it really take? So first thing is, Moderna has already put out its patent somewhere in the open. It's already there since August of last year. 30th of August or something, it just published some details on how actually it produces its vaccine. There's also been 2 teams in the US, research teams. They've tried to reverse engineer how to put out the Pfizer and the Moderna vaccines, and you know, whether other companies can do it or not. Now, the problem is not that Moderna is going to share its patent or Pfizer BioNTech is going to share its patent. For me, the problem is that Moderna doesn't own each of the patents that it uses, right? So what we're talking about now is a new situation. Vaccines for COVID-19, they come from different vaccine platforms. So if you take AstraZeneca, it's a sort of a more traditional vaccine platform. We're talking about Moderna or Pfizer BioNTech, we're talking about mRNA vaccine platforms. And in this context, Moderna doesn't own all the patents that it uses. So just to give you an example, it uses modified nucleosides. And this modified nucleoside was actually discovered by the University of Pennsylvania and then sub-licensed to a firm called CellScript. And Moderna and Pfizer both have sub-licenses from CellScript actually to produce this, right? In the same way, you know, you need a synthesizer to put out mRNA vaccines, and these synthesizers have multiple patents. So we are really looking at bunches of patents that need to be licensed, right, or waived, if we are talking about the TRIPS waiver. Now, in addition to that, I think that what we're missing out is know-how. We don't have, many companies in the world don't have the know-how to put out these vaccines, right? And they also don't have the public funding to scale it up. So in the US, what happened was that the Operation Warp Speed chose these 8 8 firms across 4 platforms and spent $12 billion actually to incentivize these firms to produce it. Now, if you're going to ask what's going to happen when we have the TRIPS waiver, then I think we need very strong industrial policy in other countries to support competition to emerge. And here for me, the issue is not to expand the waiting pool by just asking existing firms like Serum Institute to manufacture 2 more vaccines. I really want to see a dynamic expansion of this market. What I want to see is I want more suppliers, more manufacturers entering this market and surviving in this market as suppliers of cheap medicine. This is what we want from an access to medicines perspective. And I think we're a long way from creating that. So if we want to really create that, we don't just need a TRIPS waiver. We need a TRIPS waiver which is actually targeted to increasing the supply of competition in this market. And we need really facilitated tech transfer and know-how transfer to other companies who can do it. Now, the CTAP mechanism has come up with a new hub and spoke model. So the WHO has issued a public call for companies who are in developing countries who actually want to manufacture these vaccines. They can now apply. The hub and spoke model is once again a very complicated sort of mechanism. It requires a hub, a company that does actually the core thing, and then spokes are about 4 or 5 companies in the region which are going to do fill and finish. Okay. Now, how this is going to work is really unclear. So I just attended a meeting with the CTAP about 10 days ago with civil society and other organizations, and we're not clear how the hub and spoke model is going to work.
Yeah, I did have a question about CTAP specifically that way. I was curious to understand, is it supposed to operate like a public health oriented patent pool essentially? I know you just said you're not sure, but if you have anything you could throw light on with regard to what the actual mechanism is supposed to be of something like CTAP, which to my knowledge seems like a fairly unique venture, at least in that sense. It's a good step forward from that perspective. That would be helpful. Yes.
Actually, it's not clear yet. So when Costa Rica originally made the call to WHO, right, it was supposed to be a pool where all COVID-19 related technologies are made available, right? Now, it's not clear now if CTAP is going to become a voluntary licensing pool, right? Whether they're made available in terms of voluntary licenses issued by originator companies. And if that's the case, whether CTAP then overlaps with something like the medicines patent pool, which we already have in Geneva, right? But is only meant to operate for COVID-19 technologies, or whether CTAP has the authority to simply say all the proprietary technologies for all COVID-19 treatments, not just vaccines, but also drugs and rapid antigen tests. They're all made available here and there can be accessed. Whether it's going to be a sort of a technology mechanism of that sort, that's not clear. We're very far away from that. I have to be clear about it, because the CTAP is very far away from sort of like articulating itself as a body for technology access. What it has done now is come up with this hub and spoke model, which is its first initiative, and it's directed towards vaccine development.
Got it. Thank you, Padmashree. Prashant, yeah, sorry, you had something you wanted to raise. Please go ahead.
Yeah, on this TRIPS waiver, I have slightly unpopular views on this. Professor Yogesh Pai and me, we had written a piece recently in the Economic Times explaining why this TRIPS waiver is not such a big deal for India. Because for the first time, we've seen Western vaccine manufacturers actively licensing their technology to India. So, for example, AstraZeneca, Novavax have both licensed their technology to the Serum Institute of India, both their COVID vaccines. And Johnson & Johnson, and this was done last year, way before this TRIPS waiver became a big deal. Then Johnson & Johnson entered into a deal with Biological E in October last year for manufacturing its single-dose COVID vaccine. The Russians have licensed their technology to more than one Indian company. And then you have Bharat Biotech's vaccine. Notwithstanding all the safety concerns around the vaccine, people seem to be okay with taking it. So there is enough vaccine technology, at least for India, in terms of to manufacture. The trouble that we have faced is scaling up, manufacture itself. One problem is we've put too many eggs in the Serum Institute basket, where we don't know, and Poonawalla is not very transparent on what exactly is happening at Serum Institute. It's almost comical to see what happens between him and the government every day. He'll make a statement, the government will come out with a clarification, he'll come out with a clarification. So the problem, I don't think, is access to, is not patents or access to technology in India. We have more than enough access to technology in India. And even patents are not a concern. I'll tell you why, at least for certain new technologies in India, is because it's the life cycle from patent application to patent grant can easily be 3 or 4 years in India. If a pre-grant opposition is filed, it'll be even longer than that. And under Indian patent law, you cannot sue for patent infringement until the patent has been granted. Although your rights and privileges start running from the date on which the patent application is published, which means you can get royalties for the time period that you've lost, but you cannot sue for an injunction until such time that the patent has been granted. So for the next 3 or 4 years, you can go ahead and manufacture whatever you want to, your RNA vaccines, etc., etc. The reason it's not happening is because vaccines, as has been repeated ad nauseum by so many people, are difficult to reverse engineer. They're not like small molecule drugs, which are relatively easy to reverse engineer. Vaccines are just tough. I mean, you need cell lines, etc., before you can reverse engineer it. On the RNA front, I mean, this is path-breaking technology. I don't expect the Americans, whether it be Pfizer or Moderna, to just hand it over on a platter to anybody. I think our only hope is the project, the PPP between the Department of Biotechnology and Genova Pharmaceuticals. There's an ongoing project in India where the government is funding the development of an mRNA vaccine. And we have to see how that plays out in the near future. If that succeeds, then we don't have to depend on the Americans for that particular technology. And I think these reasons together is perhaps the main force behind the Biden administration agreeing to the TRIPS waiver for the limited purpose of vaccines. If you read the USTR statement, it's limited to vaccines, no other therapies. Because I think the Biden administration has figured out that this is not really going to affect us because nobody else can reverse engineer these vaccines. We may as well score some brownie points with the public health activists and all the various people pressuring them to sign up for the waiver. So I think that's the politics behind why they've agreed to this particular waiver.
Yeah, that and the fact that it's made very clear that this waiver is going to be negotiated by text and that it's going to take its own time. Yeah. So that's another easy brownie point.
The devil is in the detail with all these.
And also I think that by the time the waiver is being decided, there's going to be enough supply. So I don't know. I think it's also strategic. It's strategic. So it's sort of. Yeah. I'm not going to hold my breath, but I've got a couple more sort of very not very. I would say very controversial points to make on this, right? So I want to separate a few things. Now, for India itself, the TRIPS waiver is not necessary. So this I agree with Prashant, because you've got SII, which has 2 licenses, okay? But SII is a company in which one should not put all their eggs, because even by SII's own projections, it's producing 76 million vaccines a day right now. It wanted to scale up to 100, but hasn't managed because of some fire in the factory. So I think the Indian government has given a loan. We'll see what happens. Out of this 76 million, actually SII has a contract to supply a large share of it back to COVAX. So, I mean, it's a simple maths game. So if we have more than 1 billion people who need to be vaccinated, 2 doses of the vaccine to get, full immunity, how many vaccines doses do we need? And how much can SII produce? And how much of that should SII be supplying to the domestic market if India really wants to position itself as the pharmacy of the world and continue to supply to COVAX and other countries? Okay, so that's a very simple maths game, which apparently our government has not managed to do, right? That's one thing. Then the second thing is, now, why do we only have to think about SII when we have other firms that can actually start producing vaccines? The reason for that is vaccine manufacturing is way more difficult than pharmaceutical manufacturing. And up until COVID-19, the vaccines market was not very lucrative. So even internationally, it's only after COVID-19 that you see big pharma, really like GSK and Pfizer entering really, no, actually not true. GSK was already manufacturing vaccines, but you see lots of other big pharma entering the vaccines field, right, in a more prominent manner because it is more lucrative now. Right? Now, then the question is, what kind of vaccine manufacturing are you going to do? Can you actually do antigen manufacturing, which is the same as producing APIs, more or less, if you roughly sort of draw a line with pharmaceuticals, or do you want to just do fill and finish? If you just want to do fill and finish, then anybody else can do it. So if you really want to do the former, what kind of support structures do you have domestically that's going to enable more firms in the Indian market to start doing that and compete? And this then goes back to my fundamental problem with the situation in India right now. We don't have a systemic thinking around these topics. We don't really say, look, we could have done the same thing that the UK did or the US did. Of course, not 12 billion US dollars, but come on, you can invest a little bit less, but you can really invest. You can give public funding for firms in a more competitive process to try to upgrade their technological capacities and start producing vaccines. Why haven't we done it? And why do we actually just rely on Serum Institute of India to come and save the day? There are sort of like not many answers to this, but I mean, it seems pretty clear why we haven't done it. A lot of it relates to sort of inability to competently, configure a sort of a response to the pandemic. Also, the government trying to now say that it's going to have enough vaccines. It's just, it's not credible. It's not at all credible. Then the other question is, in the context of mRNA vaccines, what are we going to do? Do we have the capacity to produce, and who's going to put the money, right? Who's going to put the money? Somebody's got to put the cart before the horse, and putting the money is the most important part, because if you don't put the money, it's not just about the patents, it's about the production process. And when you put the money and come out, do you have a market for it? I don't know that, because Big Pharma says it can already produce 12 billion doses. This is the forecast that we have from companies which already have mRNA capacity. So then does it make sense then for other countries to start producing? And where is the TRIPS waiver going to lead us? It's all up in the air, honestly.
If I can add a couple of points, Rohan, I think India has enough money to put into R&D. The only problem is that money is going towards cow urine, cow dung, and recently the Gayatri Mantra. Apparently, AIMS is doing some clinical trial on whether the Gayatri Mantra is going to help cure COVID patients. So a lot of these issues that Padmashree is raising are, intrinsically linked to the politics of this country. We are becoming the stupid country. We're becoming stupider and stupider with every passing day. Like, how is this money going to such nonsensical, research projects? You should look at the Ministry of Ayush. It has 4 councils underneath it. One council for research in Ayurveda, one in Unani, one in homeopathy, and one in something else, I think in Siddha or something like that. Cumulatively, these guys take up some 200, 300 crores every year. For what? They come out with some Ayush 64 drug. In the 80s, it was sold for malaria. It wasn't sold. They said, oh, it's going to cure malaria. 10 years ago, they said it's going to cure, I think, some diabetes or something. And now they're putting it out saying it's going to cure COVID-19. So these are problems that are not going to be fixed in this generation. This is not only a BJP thing. All these councils were set up under Indira Gandhi in the 60s. And Morarji Desai took it a little bit more, took it a bit ahead. And the BJP is just playing on the same bandwagon. So, I mean, this R&D priorities in our country are just completely messed up. I think the silver lining is the DBT does fund some decent projects. I mean, there was a rotavirus vaccine project, which was a collaboration between Stanford, DBT, and Bharat Biotech. It came out with a new vaccine, which did have a few problems initially, but seems to have taken off after that. So yeah, I mean, I think we do have enough money. It's just like our politics is so messed up that I mean, it makes my blood boil to see money going, to cow urine of all things. But another point before I end this, what a lot of people are not talking about, and Dinesh Thakur has written a piece on this for Stat News, is that India right now is actually stealing vaccines from Africa, from COVAX, because the initial risk, the initial money was all put in by the Gates Foundation and Gavi into Serum Institute. They gave $300 million by November. Like while Modi ji was twiddling his thumbs, these guys had already pumped money into Serum Institute to make it scale up its facilities so that it could manufacture vaccines. And they had a contract for 200 million doses with an option of another billion doses to purchase from the Serum Institute. Serum Institute exported just 20 million doses before the government of India clamped down on exports. And they clamped down on exports in, I think, end of March or April. And those other 180 million doses which COVAX is owed has, God knows when they're going to get it. And this government is so shady that it has not announced a formal export ban. If you search, you will not find any legal order saying there is an export ban. In fact, the MEA is on record saying there is no export ban. But you can see from their records, since April 21st, nothing has been exported. So we have gone from, boasting in January at the World Economic Forum that we are going to be a savior of the world in terms of vaccines, to now stealing away vaccines that were already paid for to supply to the poorest countries in the world. So I think we're in a pretty disgraceful situation right now.
That clearly is an issue, and I think it speaks to a larger, point than we have the scope for discussion for this particular point, this particular forum. But I get your concern on this particular front. What I am curious about separately is also, I've been noticing at least that we have been seeing a lot of country initiatives towards compulsory licensing, towards operationalizing flexibilities. I know we've talked about CTAP. I know we've talked to some extent about the WTO waiver. What about, countries like Israel or Canada, or even Chile or Brazil or Russia, for that matter, decide that they are going to start instituting some form of compulsory licensing regime, and they all have to some extent the other made statements to that effect. Where does that put us in this context, and what does it mean also in a bigger picture, in the larger picture, given the fact that countries like Israel are meant to be IP originators and are never at anywhere near where we are on the USTR 301 watch list?
So actually, this is a very interesting question. Take the case of Russia, for instance, right? Now, the Russian Federation has, very strong domestic preference for local production. So they have actually, and which is not just in, they have a local procurement regime, which says that out of for every procurement, okay, they're going to see and cross-check if there are domestic manufacturers who cannot produce those drugs. And if those domestic manufacturers are able to produce those drugs, they're going to give the procurement contract to the domestic manufacturers. And then you have to license the technology to the domestic manufacturers to produce. Now, this is a very interesting way of combining procurement with, working and licensing in Russia. And I think that a lot of other countries have enforced it. I don't know, I think about last year, I did a study for the US National Trade Foundation on trade barriers. And what you find is that even countries like much smaller countries like Algeria and so on, they are imposing specific requirements for biosimilar drugs, for drugs in specific categories, saying that if we have domestic manufacturers in these categories, then we are going to deal with foreign registrations in this manner. And you can only enter the market when you satisfy these requirements, right? And I think that in the post-COVID context, a lot of this deserves much closer attention, in the sense that what is going to happen to the question of, just having patents and being able to produce and supply at your whim and fancy in other countries, okay? And that's also the reason why the TRIPS waiver negotiation, I'm going to just take a wild guess and say it's not going to go so smoothly. And that's why countries want it by text, and that's why countries only want it for vaccines, right? Because the US pharma has already expressed lots of concerns about these linkages between the domestic production and procurement in specific categories of drugs. So I'm going to venture out to say very safely that we're going to enter a new area, or a new phase of this battle between, patent rights and how we're going to protect patent rights and what are going to be the exceptions to these kinds of exclusivities, either recognized in the TRIPS agreement or in free trade agreements. And how are we going to sort through it in a post-pandemic world? It's not going to be that easy. Now, let me just say that Israel and Canada, right? These are countries that have already secured large number of vaccines for their populations. So if you see Canada, it has 10.6 doses per person already procured through existing arrangements and new arrangements that have been put out. Israel is quite safe. It's in a cushy place because it already signed certain agreements with Pfizer BioNTech, right, to share data and to administer the doses for all its people. You also have countries like New Zealand now, which are these are countries that have actually somehow, ensured their survival. And so for me, those countries, yeah, they're going to probably fight for TRIPS waiver and TRIPS flexibilities, but not so much. The countries that can't survive and that badly need the vaccines, right? Those are the countries that need to fight harder in this current context.
If I can add on to that, I think, the Russian-Israeli compulsory licensing cases, I think pertain to remdesivir. And the reason that in India, like I know the Supreme Court, including Justice Bhatt in one of his orders, had hinted that, nudging the government to invoke compulsory licensing provisions for remdesivir and tocilizumab. Now for remdesivir, the fact of the matter is Gilead has already issued 7 voluntary licenses to 7 different Indian pharmaceutical companies. And apparently there's some 20 plants manufacturing remdesivir. The reason that we've seen shortages is most likely because as everybody thought the pandemic was over in India by February, so did the pharmaceutical companies who started winding down production. And it took some time for them to scale up again once they realized that this pandemic was back. And it was there's a massive distribution failure in the country because of black marketing. Even steroids, which are not patented, are reportedly in short supply in certain parts of the country. These are not even expensive drugs. Remdesivir is still an expensive drug. And the second drug, which is tocilizumab, which came up in the Supreme Court orders, that's again, it's a biologic, which means it's not impossible, but it's difficult to reverse engineer, and it will have to go through a series of clinical trials before it can be validated. I think one Indian company called Hetero is already on the job. It's not clear how they're navigating the patent issues, whether they're filing for a compulsory license or whether they've just decided to, launch at risk by infringing the patents. I don't think anybody so far has filed compulsory licenses for vaccines. In fact, I don't think I've ever heard of a single case in the history of patent law where anybody has filed a compulsory license for vaccine, partly because due to the nature of the vaccine market, it's very different from the regular pharmaceutical market. You have only wholesale buyers, very few, retail buyers. And also because of the technological issues that we discussed earlier, where vaccines are difficult to reverse engineer.
Thanks, Prashant. In that context, I see a question which has come up, which I think is relevant to the discussion you're having around voluntary licensing. I think it's something worth getting into. Question is, do you think the terms of voluntary licensing would be permissive of expansive manufacturing in India to facilitate access to vaccines and technologies licensed? We don't have access to any of the terms of the license, as also the export restrictions that might come with it. How can we trust these terms, especially given the bargaining power involved? The waiver at least helps us helps the bargaining power. And on the for India aspect, I think with our manufacturing capability, there are supposedly 22 centers to manufacture widely, but we don't know its efficiency in terms of this particular vaccine. Aren't we supposed to help the global south get vaccinated rather than just ourselves? So thoughts from honorable panelists on this would be helpful.
Well, I mean, there's in the two voluntary licenses that Serum Institute has, it's supposed to supply to COVAX also. So it's supposed to actually help the rest of the South also get vaccines. And well, okay, so the bargaining power question is interesting because I've always maintained right from the time that India and South Africa submitted the TRIPS waiver proposal that for India, it's not about domestic manufacture. It's about export markets, right? It's about being able to export because India could do whatever it wants to do with the amount of vaccine technology that's already available. India has the capacity to do it, okay? For other firms, it gets more tricky because take the case of BioVac in South Africa. And they had the flu vaccine technology transferred to them. The vaccine technology transfer itself took 4 years. And then BioVac took about 10 years to then effectively manufacture this and to supply it on a wider scale. Why? Because vaccine technology is harder than normal technologies to manufacture drugs, but also because I think Prashant just alluded to this, you really need procurements, right? You need governments to procure the vaccines. They happen to be your main sort of clients. So you need that. So I would say, yeah, the TRIPS waiver is about bargaining power in a certain sense, absolutely. But for Indian firms to produce and export to the South, I don't think you'll have a lot of backlash if Indian firms are about to produce and supply AstraZeneca or J&J vaccines to the rest of the South. The point is that we haven't gotten there yet. And let's not forget that Sputnik 5, which has an efficacy of about 92% now proven, has been licensed by the Russians to more than 10 companies now. So we have 5 Indian companies which have received the vaccine license. And in addition to that, the Russian International Investment Fund, I think it's called, or it's the Russian Investment Development Fund. I'm not fully sure of the name. They have been trying to broker technology transfer with firms in Africa. 2 firms in Egypt are going to start producing it. There are going to be firms in other parts of Asia that are going to start producing it. So I think that if we want to step in the vaccines field in a prominent way after supplying to the domestic need, we have to up our game. And if we wait for the TRIPS waiver, we might not be able to do it because the TRIPS waiver, I don't think it's going to come tomorrow. It's going to begin now, the negotiations on the TRIPS waiver.
If I add a couple of points. On how permissive these voluntary licenses are. I mean, obviously haven't seen them, but I suspect that they are quite permissive because if going by the news reports, the deal between Johnson & Johnson and Biological E, what was announced was initially for 600 million doses. And this is a single shot vaccine, right? So it it would be enough for almost half the Indian population. Plus, the Quad is pumping in money into the same deal to up it to 1 billion doses so that it can be supplied to the Pacific Ocean, Indo-Pacific region countries as a part of the Quad's diplomacy against China. And similarly, if you look at the counts that have been put forth in the case of Novavax and AstraZeneca with Serum Institute, I think that it crosses like 1 billion doses easily. And there's an incentive for these vaccine companies to be quite permissive when it comes to these kind of deals, because they know there is no way they can supply the entire world. And if you look at how the pharmaceutical market has been developing over the last few years, they've been granting an increasing number of voluntary licenses to the developing country manufacturers. And the major terms of those deals are not even the royalty. It's that you can export only to other developing countries, don't come into our markets in the West, because that's where the high margin, high profit can be made. And you can see this, like for example, Gilead is, I think, a pioneer in this strategy with tenofovir, with this hepatitis drug, with remdesivir. They are granting out licenses left, right, and center in India. And I think at a certain level, these companies have also figured out, after a lot of pain, that the Indian market is actually not that lucrative. There's been this big miscalculation of the Indian market of having 300 million people in the middle class, which is clearly incorrect. The Economist and all these other magazines have written about how these estimates are probably overestimates, and the paying capacity of Indians is actually quite low, even of upper middle class Indians, which is why all these drugs are sold at highly differential prices in India when compared to the West. And Sovaldi is a great example. Gilead's drug for hepatitis, which is sold for $84,000 in the US. And I think in India, a year's course is something like 8,000 rupees or something like that. So I think the pharma industry also has become a little bit smarter. They want to protect their more lucrative markets.
So let's, while we have a chance, also address at least the statements made by the Indian courts with regard to the patent scenario on COVID-19. I think Delhi High Court has made strong observations in Rakesh Malhotra versus Government of India, and the Supreme Court as well made some fairly important statements in the distribution of essential supplies and services. What is your take in this context? I'd also really love to hear the views of Madam Sridevan. What is your take on these statements? Is this enough? Is there something which we need to do more than this? I mean, maybe it's a rhetorical question I'm asking here, but I'm just tossing it out there. It's good that we are having an observation by these courts. Where do we go from here, basically?
The observations, they will not go into the order, right? That we saw recently with the Madras High Court Chief Justice's observations about the Election Commission and what the Supreme Court has said about it. At best, I'm hoping it will translate into something more. At best, it assuages collective anger. At best. The Supreme Court itself has said it. I mean, at least the English people reading public. Because I think there is a strong divide. I really don't think that the non-English readers have the I don't know, I won't even say benefit. Read it the same way, let me put it like that. Read it the same way as the English reading people. So I really do not know. So I will say that if that catalyzes others who can act to act, then we are somewhere getting closer to the end of the tunnel. But if it ends with just fulminating, then I don't know. I'm sorry that this is this is the truth. as far as I can see.
Noted, madam. And thank you for that. Noted. Okay, yeah. Prashant, Padmashree, any thoughts on this front?
I don't know. I think we're in the era of performative jurisprudence where the court makes these nice noises. You know, it's basically performing for, as ma'am said, the English-speaking audience who seem to have lost a lot of faith in the court over the last couple of years. So it said a lot of nice things which won it, you know, accolades within the press. But again, like I said, in real terms, when it comes to compulsory licensing, what are you going to issue compulsory licenses for? Because of the 3 drugs that are used for treatment, steroids are not patented. Remdesivir, you already have 7 companies manufacturing it in 20 plants. And you have tocilizumab, which, okay, you grant a compulsory license for that, but it's going to take time to come to the market. It's not going to be anytime. I guess it'll take at least a year for them to come to the market. So in this case, what exactly is the compulsory license going to solve? You know, in a pandemic like this, it's very important to have a nice villain. And I mean, it's small mercies that we're not targeting religious minorities this time round. So IP law is usually a popular villain in these debates, but I hate to break it to a lot of people that this time it's just not true. I mean, all the IP has been licensed voluntarily. So the Supreme Court must have, it's coming from a good place, I'm sure, but there really is nothing to issue compulsory licenses for. What they should have done is to ask the government to draw up a proper vaccine procurement plan and place it in front of the court. That would have been poking the tiger in the eye, because it would have just shown us how incompetent this government has been when it's come to, you know, planning for vaccine procurement. That has been the real disaster.
I have a couple of points to add here. I think that, I mean, remdesivir, right? So out of the voluntary licenses issued by Gilead, 5 are with Indian firms, right? You have Hetero, you have Stride, you have Cipla, you have 2 others. They are manufacturing the drug. Now, this drug, the Gilead license, for instance, for remdesivir, is not only supposed to manufacture for the Indian market. Yeah. The 7 firms that have received the voluntary license, they're supposed to manufacture and export to all the other low and middle income countries. So there is space for the Indian government to systematically ask what's the production capacity of remdesivir that we have today? How much are these firms producing? How much are they exporting? And do we urgently need actually more remdesivir in the local market? Can these firms themselves expand production capacity, or do we need to take other steps? I haven't seen any of this happen in any systematic manner up until now. And that's actually very problematic, because that's very different from how such a thing would happen in the US market or any other market where you have a certain level of government accountability to availability of medicines. I'm not even going to pricing. I'm just talking about basic availability, right? Now, then comes the question of affordability. Okay. Now, why is this drug suddenly so scarce? Now, I mean, of course, we thought we defeated the pandemic, but the firms did not produce less of remdesivir up until then. They were producing probably the same amount of remdesivir that they were producing under the voluntary license, because voluntary licenses usually have sort of pretty generous clauses, and all these countries that were importing from India continued to import because they had COVID surges. And remdesivir is not a COVID drug per se, it's a drug actually which is used for a wide variety of things, right? So why actually did these firms not have sufficient stock, and where are we heading with the supply of remdesivir is something we've not discussed. So I find that very problematic. So if the court comes up with a statement like this, who is the person or the agency or the governmental body which is supposed to act on it? And why haven't they acted on it? And what is the level of control that the courts can exercise, and who can exercise control for this? Okay, so this is something we need to answer. We're not even there. People are dying without those drugs, and we're not there in a place where we can have a serious discussion about what's going on in the country. And I find that really problematic. Then the other question is of pricing. Now, the main thing that Indian firms are supposed to do, and I'm saying this in a very lax way, because this is how we've always operated, is to offer wide variety, a wide amount of supply at cheaper prices, right? And we're supposed to do that in the interest of access to medicines. That's one of the arguments you hear time and again in this argument, also within India and outside of India. Okay, and I don't see that happening, not just in the case of remdesivir now. I don't see that happening also in the case of the pricing that has been announced by Serum Institute of India, actually, for these procurement of these vaccines by the state governments, right? And this goes against the core principle of having tiered pricing by firms, because if firms were going to tier price within a country, then what you have to ensure is that you have to ensure that if there are 2 or 3 categories of prices, that the higher category of price is in the private market, the lower categories of prices are in the public sector, meant for people who can't afford the higher category of price. There is no accountability to this, to say the state governments will pay 400 rupees. Oh no, oops, no, now 300 rupees per vaccine dose, right? Whereas the central government is going to pay 150 rupees. And who is sitting and saying this kind of pricing is wrong and we're not going to accept it? And I really want to have a debate on why we're not having a debate about these things. Why are we just debating voluntary licenses and compulsory licenses?
Yeah, I mean, the vaccine procurement policy.
Sorry, if I may just it's an interesting observation I have to make. What we're noticing here is that in a discussion around intellectual property related issues on the COVID-19 pandemic, I think we're circling around the conclusion that our problems are far deeper than IP, basically. And that's an interesting sort of consensus I'm seeing developing here.
Yeah, I mean,
Where's the doubt about that? Where's the doubt about that? It was because of the deeper problem that we are in a darker mess.
Very true.
Yeah, true. I mean, this vaccine procurement policy is just bizarre. I mean, the government of India should have been the single point negotiator, create a monopoly situation where, you have one buyer for everything, and the prices would have been rationalized much better. Like, even if the government of India didn't want to pay up for everything, it should have at least negotiated on behalf of the states and then taken its pound of flesh from different state governments. This bizarre Hunger Games that it has launched between state governments, it just makes no sense. I mean, if we can fund research for cow urine, this vaccine procurement policy also is possible in a country like India. No rational explanation to any of it.
I think we're a good time now to start taking a few questions as well, and sort of going through the fairly large body of questions which has built up during the course of this discussion. I'm just going to start by taking a question from Amman Sinha for Prashant. It says, in the current situation where the government is on record saying that doctors should prescribe better Indian alternatives instead of foreign-made drugs like toxicizumab, etc., how do you deal with, this after vaccine nationalization, now drug nationalization, equating steroids to toxicizumab? My head is spinning since I read this. Less frustrating question: what can be done to ensure that toxicizumab may be available to all people needing it? I mean,
okay, just to give some background to this question, I think the Bombay High Court Chief Justice recently made some comments like we should give preference to Indian drugs over foreign drugs. And itolizumab, which is manufactured and produced by Biocon, it's Biocon's own product, is apparently supposed to operate similarly as tocilizumab, except itolizumab's approval has been heavily criticized because of the way its clinical trials were designed. So there's a lot of skepticism on whether the drug will perform as required. And more controversially, itolizumab wasn't included in the national treatment guidelines although it was approved by the drug regulator. So it's an interesting situation where, even the COVID task force of the government of India does not have faith in the Drug Controller General of India. Because if the drug was performing as the DCGI certified it was, it could have been included in the national treatment guidelines. Now, I think the first question here, it's not even an IP issue. First question here is whether judges should be wading into these kind of issues on what kind of drugs should be prescribed, etc. I think that this is outside the purview of the judiciary. It's dangerous when they make comments like this, because then they're picked up in the media. And a lot of people in India still believe the words that fall from a judge's mouth. They're treated like the holy scriptures. So, that is one issue on the, the line in public health cases that judges ought not to cross. The second issue on what can be done to get, to ensure the wider availability of tocilizumab, unfortunately, not a lot, because the drug primarily is manufactured by Roche in some foreign markets. It's not manufactured in India. And building that manufacturing capacity, India can do it. We've done it for other biosimilars, but it takes time because a biosimilar, unlike a small molecule, is required to go through all three phases of clinical trials because they have to be validated afresh. So that takes time. In the short run, I don't think much can be done to boost the availability of tocilizumab. But on a medical point, from what I understand, steroids do the job equally well. It's only when, for some patients, steroids may not be working because they're used to taking steroids that you need to prescribe tocilizumab. So, the other part of the story is the way the medical profession in India has been, providing treatment in the sense that we get that a lot of drugs which are not required are being prescribed. So, for example, there's this other drug which is being sold by Glenmark called FabiFlu, which is actually a Japanese antiviral drug that was developed for influenza. It was repurposed in India for COVID. And again, its clinical trials came under heavy criticism from the scientific community, the way the clinical trial was designed. And I don't think FabiFlu is even mentioned in the national treatment guidelines. But people have gone berserk over this drug. And, we've seen municipalities and all buy millions of doses. So, that is the other part of the story, which is beyond this panel, and how doctors have been prescribing drugs. And they work in a complicated environment in India because Indian patients love to take medicines, and there's a lot of pressure on doctors to prescribe all kinds of medication.
Thanks, Prashant. An interesting observation, not exactly a question, but it's still worth getting into. This is from KB. It goes as follows. It's interesting to note that when the TRIPS waiver and tech transfer was being discussed last year, the response was, it won't do much in the short term. Same response now. And we'll get the same response next year and the year after that. And pretty soon we'll be a decade into discussing the short term. This pandemic is not going anywhere in a hurry. If we need repeat vaccinations every year and we're going to need treatment because of new variants escaping the vaccines, then these limited licenses are not going to get us anywhere. And if you think of coming pandemics, then we have to start thinking of setting up and expanding capacity now. Padmashree, Prashant, any thoughts on this which are worth getting into?
Yeah, capacity, the government has to invest in building capacity, either by, directly building, like it's got, there's a brand new plant in Tamil Nadu somewhere, a vaccine plant, 900 crores put into it, which is not manufacturing any vaccines. It's just been lying still. So one part is to try and reinvigorate the PSU sector. The other way to do it is to assure the private manufacturing market that the government will buy a certain number of vaccines every year. And that would be enough of an incentive for them to set up and expand on their existing plants. On the TRIPS waiver, see, even in the long term, if you have a waiver for TRIPS, the essential question is, even if you waive your patent rights and trade secret rights, how are you going to get the know-how? the know-how has to be given to you by a particular person, which is not going to, you can't force somebody to come and teach you how to make a particular vaccine. So the TRIPS waiver, I don't think, even if it comes through, it's not going to really make much of a difference on the ground, unless you want to take like the Brazilian route. The Brazilians have waived everything, and they've promised to penalize countries which don't transfer their know-how to Brazilian companies. That is, I think, by revoking their patent rights for other drugs or something like that, which is basically setting yourself on course for a trade war with the Americans and Europeans. Building up capacity is the only way which the government of India either invests its own money or it comes out with a plan and a partnership with the private sector to ensure that that money does reach, that there is a viable market for these guys to set up their own plant.
So I've got a couple of points on this, right? So I think that, the TRIPS waiver, we've got to sit and consider it in sort of its entirety. So on the one hand, you want these licenses to be waived, these patent rights to be waived, trademarks to be waived so that people can produce. But on the other hand, we also want actually the big pharma, in this case, Moderna or Pfizer, BioNTech, and so on, to continue to investigate how they can tweak their vaccines to cover new COVID-19 variants, right? So even in the most generous scheme, how are you going to preserve these incentives is an important question that we do need to answer. We do need to answer the question that if you're going to address and offer a blanket TRIPS waiver, what's going to happen? Okay, so and that's something that is going to become an issue when the TRIPS waiver is discussed. So probably the TRIPS waiver will only cover the technologies that are already available up until now. With that, it will provide the incentives to actually the big pharma companies that have actually important patents to innovate further. That's a possibility. We can think about it. Then how do we expand production capacity? In my view, production capacity for vaccines now is not just about establishing more fill and finish capacity. This fill and finish capacity is relevant in the short term, but in the midterm and the long term, what we really need is vaccines R&D capacity. This is what we are going to need. Because if you see what happened with COVID-19 is that even when the genome sequence was made available by the Chinese in January 2020, it's only a handful of firms that were able to come out actually with products. And these were the products that came out because of vaccine R&D capacity that was already there in those countries, and also because of the fact that select countries really invested into industrial policy in this sense. If you take the US, it's a very classic case, but UK invested in it, Russia invested in it, China has invested massively actually into enabling its firms to increase its R&D capacity to produce drugs, right? And this is very important. And I think that we need to consider the discussion on patents, in parallel with the discussion on capacity, right? So how do you build the know-how that's required for these firms to perform better in a much more challenging R&D environment, and in an R&D environment where you really need fast results, and you might read even faster results as we have more pandemics, right? And on that, the technology transfer issue becomes important. Since the 1960s, in the international field, the technology transfer issue has been very, very, very tricky. And with every discussion on IP, we reopen the discussion on transfer of know-how. And there has been very little movement on the side of transfer of know-how. So how are you going to make transfer of know-how a prominent part of IP discussions? And for me, that's a very important area where we need to move internationally. And there I have to say, let's not forget that IP is not just about the pharmaceutical sector. So if you want to waive all patent rights in this context, it's going to have repercussions in all other sectors. And this is the reason why, for me, actually, that to maintain this balance in some way, to get to a situation where we are able to consider the transfer of know-how in a more meaningful manner, along with licensing, is really important. A final thing that we don't discuss is when you have voluntary licenses, right, for vaccines, you have the possibility of using the clinical trials of the original manufacturer to introduce your vaccines, right? Now, what happens if you would issue compulsory licenses for vaccines, okay? And companies had to redo, like they have to do in the case of biosimilars, all the clinical trials. Okay, this is not going to speed up your situation. It's not going to make vaccines available more faster. So there are trade-offs here, and we need to really start discussing these trade-offs.
Thanks, Padmashree. I'm going to take two questions together. One from Abhinav Gupta. Why is the government of India not exercising power under Section 92 of the Patents Act and giving compulsory licenses to eligible manufacturers for Covaxin, considering the fact that Covaxin has been developed with Government of India funds and supported by ICMR? And I think there's an associated question here, which is from Rahul Bajaj, which is a question specifically for Justice Sridevan. Section 92 of the Patents Act specifically refers to national emergency. We're currently experiencing a textbook case of a national emergency. Admittedly, CS will just be one leg of the tool, and transfer of know-how, etc. will also be needed. But are we not frustrating the legislative intent behind having Section 92 by not actively considering their use now? I think on some level, these are both the same question. So, yeah. Justice Sridevan, I guess, since is addressed first to you, perhaps your thoughts on this.
But part of the answer has also already been given by Padmashree about the transfer of know-how. And the Supreme Court, I think, has asked, have you not considered Section 92? And they immediately said, we are not asking you to, we are just suggesting. Yeah. And tomorrow is the day, we'll know the answer. I'm sure they'll come up with an answer. And in addition to what corollary or whatever you may call it to my earlier answer, and to what both Prashant and Padmashree said, if the Supreme Court can insist on an action taken report and an action to be taken report to be regularly given, we'll all be wiser and more enlightened. At least we'll know what is happening. It may not be what we want, but we'll know where we are. That I don't know. That's something one wishes happens, because we generally don't know where we are, and we are relying on all kinds of hazy rumors and which may not be true and which may be fear mongering, which is not really what we want now. So Section 92, this is my answer. Some of it has already been answered, and the Supreme Court has asked the center why it has not considered issuance of Section 92. And I agree there cannot be another situation of national emergency and extreme urgency than today. So this is not probably what they were thinking of. I'm sure the pet lawmakers never thought of something like this, but something infinitesimally small, but something like this they were thinking of. Yes, maybe earlier they could have thought of. Anyway, let us see.
Thank you, ma'am. Prashant,
if I can add to that. Regarding Covaxin, one of the problems is the government is not making public the agreement between ICMR and Bharat Biotech, because actually for a project of this kind, you shouldn't even need to issue a compulsory license. The contract, the funding agreement should have been negotiated in such a way that the government retains certain rights to license it to other parties and force a technology transfer at the same time. Because in the US, they have these rights called Marchand rights for federally funded inventions, wherein the central government, the federal government in the US has certain rights over all the inventions that it funds. They never use it, but it does exist on paper. Coming to Section 92 and Rahul's question on national emergency, we have an interesting case now, which Guruswamy Nataraj has just filed, I think, on behalf of NATCO with the Patent Office, where they are trying to make the argument that under Section 92, there is already a declaration of a pandemic, but from the National Disaster Management Authority, the Ministry of Health, etc., 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 and that is enough to trigger the national emergency clause in Section 92. Now, that is a novel argument because the traditional way to interpret Section 92 is to wait for a notification to be issued by the the Department of Industrial Policy and Internal Trade, which is under the Ministry of Commerce, because the Patents Act is assigned to the Ministry of Commerce under the Business of India allocation of business rules that the Government of India follows, which means that once a legislation is assigned to a particular ministry, then all references to the central government in that particular law inherently mean that ministry, which means only that ministry can issue a notification. The problem, and we don't study this enough in the Indian context, is that different ministries in India think very differently on the same policy issue. So the Ministry of Commerce, which has to deal with the Americans in trade deals and trade agreements, Americans and Europeans, can be scared of issuing a compulsory license, or even issuing a notification on compulsory licensing. But the Ministry of Health, which has to balance the books on its health budget, would be more willing to issue a compulsory license. We've seen this even in the context of copyright law, etc. So over here, we have previous examples where the Ministry of Health has requested for compulsory licenses to be issued for some really expensive cancer drugs. And the Ministry of Commerce just didn't budge on that point. So there are also these internal politics. It'll be interesting to see how the Patent Office deals with this particular case and what happens when it goes on appeal to the high courts. So we'll probably have some clarification on what is that notification requirement in Section 92.
Okay, great. I was hoping we'd have a chance to discuss the NATCO compulsory license application. Thanks for that, Prashant. Padmashree, anything?
Yeah, I just want to say that, it's funny that we are doing the dance around national emergency when it's clearly a national emergency, first. And second is that, take the case of European countries. In the last 2 or 3 years, they've issued compulsory licenses on cancer drugs, right? Because there are very important cancer drugs that are being produced by American companies, which are not being introduced in the European market because the European countries apply a reference pricing system. So they bargain the price down to a benchmarked price, right? And so these drugs have not been introduced in Europe. And therefore, even Germany has issued actually a compulsory license about 2 years ago. And from that perspective, I think that this question of policy coordination or the ethics of policy coordination between different ministries, it's a common problem, but it shouldn't stop us from engaging in policy making that's really important and critical from a national standpoint. And I don't know how we're going to overcome that, but I think that, in many countries, including the US, for instance, there's a sort of an umbrella committee when things are important that are constituted to make sure that actually these policies between different departments are well coordinated. And that's something we really actually need. We don't have that. If we do, we don't know how this committee works, then we have a new problem with that. But we need probably some sort of transparency and accountability and better communication between the Department of Health and clearly the Department of Commerce.
Yeah, transparency. That is that is a constant problem with this government. They just do not disclose anything.
Right. So I think for the most part, we do have a few more questions here, but we covered a lot of the points already. And I think from that perspective, we're done. Unless there's something you'd like to address specifically, Padmashree, Prashant, or Madam Sridevan, the questions are in front of you.
There was one question that I thought was worth answering on this patent working requirements. Yeah,
Yes.
the one issue I think is Yeah, see, on patent working requirements and Form 27, so this patent working requirements, there's been a debate, and I think even Justice Sridevan can possibly add to this because she's adjudicated on this point. On the patents, there's a debate on whether the Indian Patents Act mandatorily requires a patent to be worked in India, in the sense that does it have to be manufactured in India, or if it is not manufactured in India, is it a ground to issue a compulsory license? Now, there are many ways of interpreting the policy behind this provision. One of the traditional explanations given is that it is a way to force technology to be transferred onto Indian soil. That's a traditional explanation that was given in the Iyengar committee report, etc. Because if you're not manufacturing it on Indian soil, then you're just importing it, there's a certain loss in transfer of know-how to Indians. Because the moment you're manufacturing in India, you're training an Indian workforce in how to use this technology. They will leave that company, they will set up their own companies, etc., etc. So that's one way to facilitate, know-how, knowledge spillovers, etc., for a developing country like India. And on the other hand, if you do force every country in the world in a free trade system to every country in the world is forcing the patentee to manufacture in their own territory, it is not feasible. It destroys the very logic of having a free trade system where the lowest cost manufacturer takes advantage and exports to the rest of the world. So that is one issue with how this working requirement is interpreted. The other issue I just briefly want to touch on is this Form 27, where it's a requirement in Indian law which flows from Section 146 of the Patents Act, I think, which basically requires patentees to disclose all their sales in India for a particular patented invention. It's supposed to be a tool to understand how well a patent is actually, whether a patentee is able to service the Indian market. And it's a great source of information to understand how the patent system is working. There have been immense efforts in the recent past to dilute it to a great extent. And I think it succeeded to a little bit. But it would be great if, those issues also are considered in any substantive policy reform debate. I think Shamnad had kept that flag flying for quite some time before he passed away. But it's somebody needs to, take up that issue once again. But it'd be great to hear Justice Sridevan's thoughts on the domestic working requirement, because I think it did come up in the Bayer case.
Yeah. Justice Rajagopal Iyengar report clearly says that working means manufacturing at home. He says otherwise there is no point, because only then the technology will be transferred. But that was before TRIPS. So when the CL case was argued before us, the controller had said that working means it has to be manufactured at home. He was very clear. And when it was argued before us, they cited this from TRIPS that the locus of the importation shall not design title. I don't remember the exact words. They cited that. The compulsory license does not really revoke the patent. In fact, it reinforces their title. Only then they can give the license. But still, this is what I would call judicial pragmatism. I didn't want to be caught on the wrong foot by saying we had violated TRIPS. So what we said was, the patent owner will have to prove that it is impossible to work it in our country. Otherwise, he has to work it here. So that has to be done, which is not there in the Act. But that's how we read it. And till now, that has not been disturbed. Because I think the Bombay bench is where it went. I don't know whether it was the Supreme Court. One of them said, we are leaving the legal questions open, but we are not interfering. What that means, I don't know. But anyway, probably they can answer this at a future date. But this was what we decided on working. I agreed with Mr. Kurian, but I didn't want it to go on that score alone. So I decided that I would word it in such a way that I was not violating TRIPS, but the patent owner will never be able to prove I will never manufacture in India. So he has to prove that. So that's what I did. And that's what we did.
You know, it's interesting. There was an old dispute between Brazil and America, because Brazil had a similar provision as law. And the Americans threatened to take them to TRIPS. And I think somebody then pointed out to the Americans that they had similar provisions in their own laws for federally funded inventions under the Air Act or Water Act or something like that. So that case, basically, it stopped in its tracks. I think there's a important policy point over there for India where, you know, if you can merge a government procurement policy like Padmashree was talking about with a patent policy, you could try and, you know, force certain technology to be manufactured in India, and that will have its positive spillovers in the Indian context. So, as Padmashree was saying, we need to start thinking about these issues, and, you know, the government needs to push the debate ahead. We've not touched the Patents Act since 2005. It's that the bureaucracy is so terrified of doing anything about patent law that we're just stuck somewhere in no man's land.
Right. Thank you, everyone. I think, you know, we've had a fairly comprehensive discussion over quite a considerable amount of time. It's been a pleasure being on this panel with you, Madam Sridevan, Padmashree, and Prashant. And I'm hoping that the audience found it engaging enough. I think our numbers just dipped upwards just recently, so that's good to know. Usually it goes in the opposite direction and then stays going that direction. So that's good. That's all from my end. Thank you. The organizers.
Thank you so much to all the panelists. It was an excellent discussion. And we've discussed everything from how different countries are looking at things, how there are institutional failures, the politics of IPR, and how we also need to start looking beyond IPR when we're looking at issues of access to medicine. And I think in that sense, this discussion was incredibly fruitful. Once again, thank you so much. It was an honor hosting all of you. With that, I think we conclude the session.